He's already forgot his name.
Pardon?
Mason is one that did not come down here from post one.
Okay,
Mason's the last name. Uncle Albert.
okay. Well. Unless he's sick or crazy, he comes.
No, this is true. I just didn't want him to ruin it for the group.
I understand. I appreciate it. Okay, good evening, folks.
You need me to send you anything up here?
Send me,
You want the link up here to your computer? So you're broadcasted as well, or are you good with just your voice?
yeah, why not? Go ahead and put it on there.
I sent you the link there.
Oh, link. Oh, forget it.
Got it.
I'm not where I can get on this thing.
Got it.
Okay, good evening, folks. My name's Kenneth Fatucci. I'm one of the judges, Municipal Court, City of Austin. We're here so that I can give you what are known as magistrate's warnings. This is information the law requires be given to you after you've been arrested and charged. And you are each here because at some point, an affidavit, a sworn written statement was given to a judge by law enforcement. And the judge found that on that affidavit, there was probable cause to believe that an offense was committed by yourself. In a misdemeanor, that's enough to have the case go to the court where it'll be taken care of, where it'll be disposed of. That is to say, county court at law, for most of the cases we have here. If you're charged with a felony, then the case will go to the grand jury. It will determine whether or not the case will go forward to the district court. In the case of a felony, you do have the right to something known as an examining trial. That's a hearing in front of a magistrate to determine whether or not there's probable cause to maintain the charge against you. Essentially a second bite at the apple of is there probable cause or not? And you need to talk to your lawyer about whether or not that is something that you wish to ask for. Now, with regard to an attorney, it's an attorney you hire or one who's appointed if you don't have the means to hire one. I'm going to ask you, when I speak to you individually, if you request the court appointment of a lawyer. If you do, I'll put it on the file of the case. From then, the pretrial service office determine whether or not you have the means to hire a lawyer and get one court appointed to represent you if you don't have the means. An attorney who's court appointed is expected to get in touch with you as quickly as possible. And if an attorney should visit you while you are in jail, you will get an opportunity and a reasonable amount of time to discuss your case with that lawyer. That's whether it's appointed lawyer or a hired lawyer. Anyone who comes to visit you, a lawyer, comes to visit you while you're here in jail, you get an opportunity to discuss your case with them. Now, you do have the right to remain silent with regard to the matters that have brought you here. You're not required to make any statement whatsoever. If you do make a statement, you need to understand that whatever you say is going to be used as evidence against you. You have the right to have a lawyer present with you, representing you when you're questioned by peace officers or by lawyers who represent the state. When you are questioned by peace officers or by lawyers who represent the state, you have the right to end that questioning at any time. You got to tell them that you're not going to discuss it any further. That can be before or during any question. Now, if you are the citizen of some country other than this one, you need to understand that a conviction of any offense is not going to help your ability to stay in this country. Also, if you are a citizen of some other country, you have the right to have the government of that country told that you're being held in jail here. That's to see if perhaps they can be of some assistance to you. So that's what you need done. Let me know when I speak to you directly. Now we get to the matter of bail. In most of the cases, there is a bail set. Bail is an amount of money used to guarantee your appearance before the trial court so that you can be released and go to court on your own. Satisfy the bail, you'll be released. If you don't satisfy it, you'll be maintained in jail until the case is over or until bail is satisfied. And there are three ways in which bail can be satisfied. You put up the full amount of the bail in cash, the law is you will be released. You go to court on your own. Then when the case is over, as long as you showed up every time, you get the money back. It's because it's a guarantee, it's not a payment. Second possibility is for you to contract with a bail bondsman or bail bond company. Now, those outfits, for a fee, will guarantee to the sheriff your appearance before the trial court. If that happens, you will be released. The amount that it costs you is between you and that individual bondsman or bail bond company. Last possible way is a personal bond. You are released on your promise to appear plus the approval of that bond by a judge. Now, that may or may not happen at this time. If I tell you it's going to happen, it will. If I don't tell you, well, then you need to talk to your lawyer about it. Because perhaps with more or better information to a judge, one personal bond can be granted. All right. I'll go ahead now, start talking to people. Mr. Gutierrez. Okay, sir. You're charged with the Class A misdemeanor, resisting arrest, search, or transportation. Bail in that matter is set at $5,000. Do you request the court appointment of a lawyer in that case, sir?
Oh, yeah.
Okay. Mr. Hayes. Mr. Hayes, sir, you're charged with driving while intoxicated, a Class B misdemeanor. Bail is set in that case at $4,000. And you are to have or undergo evaluation with regard to alcohol use by the Travis County Counseling and Educational Services. Do you ask for the court appointment of a lawyer, sir?
Yes.
Thank you, sir. Ms. Martinez?
Yeah.
Ms. Martinez, ma'am, you're charged with driving while intoxicated, Class A misdemeanor. It's Class A because they claim there is a prior conviction. And that one, in that one, ma'am, bail is set at $6,000. It's required that you have a vehicle ignition interlock placed on your vehicle within 30 days of your release. And Vic, all right. Your bail is set at $6,000 in that DWI, ma'am. It's a Class A misdemeanor because they claim that it's a second offense. The bail is set $6,000. There is a requirement to have a vehicle ignition interlock. Do you know what that is?
Yeah, I'm not vehicle.
What?
Not vehicle.
Okay, even if you don't have a vehicle, that order requires that you not drive anything that doesn't have an interlock on it,
Okay,
okay? And you are to undergo drug evaluation through the Travis County Council on Educational Services. Do you ask for the court appointment of a lawyer, ma'am?
Yeah.
Okay, thank you.
it's still 10%.
What?
It's still 10%. Of 6,000.
I'm sorry, ma'am, I can't quite understand.
Exactly. That's 10% of the 6,000. That's still,
Well, you're gonna have to do the math on that, ma'am. Talk to a bonding company if you're interested. Okay, they'll help you with they'll tell you what percentage they want. I can't guarantee one way or the other how much that might be.
Okay, have a seat. Yeah. That's the first.
All right, now, Juan Diego Martinez, sir, out of, let's see, Hayes County, there's a failure to appear in a misdemeanor case, and bail is now set at $6,000 cash or surety only. In other words, that judge won't accept a personal bond, but set up the other type, then you will be released and required to take care of that case in Hayes County.
with the bail bond.
That'd be fine. Yes, sir. Do you ask for the court appointment of a lawyer in that case, sir?
Sure.
I'm gonna note it here, but whether or not one will be appointed is up to the judge in that county. Thank you. Mr. Phipps? Oh, excuse me,
That's 3 months.
pardon?
You also have individuals in 3 months.
Okay, cool. Ms. Reyes?
Yes.
Ms. Reyes, ma'am, you've got a possession of controlled substance, state jail felony, controlled substance, being methamphetamine. And then there's a motion to revoke or application to revoke probation or deferred adjudication in a felony matter, and there was no bail in that case. You'll have to appear in front of that judge who will decide whether or not to release you on any kind of bail.
Thank you.
You asked for the court appointment of a lawyer, ma'am?
Yeah,
Thank you.
thank you.
Mr. Thompson Franklin? Sir. Sir, you're charged with interference with an emergency telephone call. That is a class A misdemeanor. Bail set in that matter, sir, at $5,000. You're also charged with unlawful restraint, also a Class C misdemeanor. Bail set at 10,000 in that one. Then, sir, you're charged with aggravated assault with a deadly weapon, second degree felony. Family violence matter. Bail set in that one at 30,000. You have no contact with the complaining witness, and there is, sir, an emergency protection order they're gonna give you now. This is a limited time order, sir, with regard to Kimberly Franklin for protection. And it requires that you not do certain things for the period from now until midnight on April 5. First is no commit act of family violence or any stalking with regard to her. Communicate any threats or harassment to her, any member of her household or family. Don't communicate any don't have any communication with her or any member of the household or family at all, except through your attorney or someone appointed by the court. And don't go within 200 yards of 13021 Dessau Road during that period of time. I note that that's the same address given for yourself, sir. If you have things over there that you need to get, someone else needs to go pick them up. Don't go, even if you're invited. Otherwise, it could be an additional problem. Okay, sir. Do you ask for the court appointment of a lawyer, sir? Thank you. And sir, you will get a copy of that emergency protection order. And I'll ask that you sign for it when you get it. And that's not an admission of any type. It is only saying that you got the paper.
Yes.
Okay, Mr. Torres. Mr. Torres, sir, you have out of district court in, not quite sure of the county, but it's Dallas County. There's a motion to revoke bails. There's no bail in that case. Now, do you ask for the court appointment of a lawyer, sir? Sir, I could not quite hear you. Yeah, well, sure. You have, if that's what you wish to do, sir. You're not required to have one court appointed.
All right, yeah.
So you intend to hire one, correct? Thank you. Dallas County thanks you too, I think.
Okay, yes, but so is it Dallas County case?
Pardon?
Is Dallas County case?
It is, sir.
Transfer me, don't
They will hold you here for Dallas County to come pick you up, or any of our people are headed up there, they might take you up. They'll get you up there as quick as they can. You'll probably appear in front of the judge up there. You may need to make the request for the court appointment again. This paperwork should go with you.
All right.
Thank you, sir. Mr. Young?
Joe,
Mr. Young, thank you. Sir, you're charged with unauthorized use of a vehicle, state jail felony, bail set 10,000. Do you request the court appointment of a lawyer, sir? Okay. Checking on something. Okay. On the recommendation of the personal bond office. You are going to be released on a personal bond. Mr. Moran? Mr. Moran? Sir, you're charged with, assault, family violence, class A misdemeanor, bail set at $10,000. Further, you're charged with unlawful restraint, class A misdemeanor, bail set at $8,000. In the, assault case, there is an emergency protection order of Chief Bailey's that requires you not commit any act of family violence or any stalking with regard to her, that you don't communicate any threats or harassment, her, any member of her household or family, or go within 200 yards of 200 East Anderson Lane. Here in Austin, it's the same address you have, so the same as I told the other gentleman. Don't go there, even if you are invited, until at least this order is over, and it will be over on midnight, 5 April. There it is, sir.
April what?
5th.
April 5th.
Yes, sir. Do you ask for the court appointment of a lawyer, sir?
I can hire my own, but I gotta.
Okay, well, if you're gonna hire one, great. Thank you. Okay, sir. Ms. Alvarado Cabrera, ma'am, you're charged with third-degree felony assault on a security officer. In which bail has been set at 10,000. You are to have no contact with that individual and to stay away from 9515 North Lamar location where that occurred. You asked for the court appointment of a lawyer, ma'am? Okay. Ma'am, you will be released on a personal bond.
Thank you.
Mr. Mack? Mr. Mack, sir, you're charged with the class B misdemeanor, driving while intoxicated. Bail is set at $3,000. You asked for the court appointment of a lawyer in that case, sir?
Yes, sir.
Okay, sir. Thank you. And you are to be released on a personal bond in that case. Pardon?
Sorry.
Means you're gonna get out. There's gonna be a small fee, but it's not gonna be needed to be paid before you're released. So hang in there. It should happen within the next several hours. And that, of course, if something else jumps up and grabs you, some other charge, then that would have to be resolved. Or have to be at least resolved as far as we've been doing it here. So folks, that concludes what I have for you. I wish you all the best of luck. You have two.